Welcome to your key discovery point. I am Burney from Nextpoint, joined by Doug Austin of eDiscovery today. Doug, you just reported on a case, I think hours ago almost, that covers the question of possession, custody, and control in regards to hyperlinked files, which this whole question of hyperlinked files is just such a quickly evolving, wishy-washy area in our legal world right now. This is an interesting discussion from the court, but I got to tell you, I've got some questions here that I feel like were not totally answered on this. But why don't you go through and explain the case for us first, quickly here?
Sure. And really, there's a couple of different issues being addressed here, but the one that really piqued my interest is the fact that one of the plaintiffs had basically sat for a podcast recording. Hey, this is a podcast about a podcast. The podcaster sent her a link of the recording via an email. So she and her attorney reviewed it, and they determined that they wanted to remove a 4-minute segment because they felt like getting into the factual specifics of the case was not a good idea given the litigation, and also I think they felt like it could be harmful to their case. So, so that's what the plaintiff Hubbard's attorney said. She forwarded the email to the podcaster. The podcaster removed it, edited the recording as requested. And basically they say, hey, the edited version of the podcast is available, but the unedited version of the podcaster was not, and the link didn't work anymore, according to Plaintiff Hubbard and her attorney. So that was basically the issue, and defendant was wanting the unedited podcast. So one of the things that's interesting about here is how Judge, and basically this is a Texas judge, Judge Elizabeth Chesney, ruling on the case, magistrate judge, talking about possession, custody, and control, and some of the considerations about that. She noted that while the recording may have remained in the custody of the podcaster and merely streamed by the plaintiff and her attorney, by asking the podcaster to delete a portion of it, Plaintiff Hubbard arguably exercised control over the file. And even though the plaintiff's yes, arguably. Well,
that's the key word for me.
arguably is yes, a very key word there. But the plaintiffs, of course, said, "Hey, we didn't have control. We were merely asking to leave a portion of the podcast out and not air it." But Judge Chesney referred to the fact that the email requested cuts, and so. She said, plaintiff's alternative reading of the email was not the most plausible one. And then she adds in the last sentence, to avoid the possibility of sanctions under Rule 37E, plaintiffs are directed to contact the podcaster to see whether it's possible to obtain the original version of the file. So the podcast is certainly in the possession of the podcaster. It's in the custody of the podcaster, and the question is it in the control of the podcaster? But the idea of if this, original, the unedited podcast isn't available, could that lead to sanctions of a file that they actually don't have, really physical control of? So. It'll be interesting to see, if there's a follow-up, if they're unable to find that file. But to me, that's one of the things that I think we talked about in our webinar last year about challenges with hyperlinked files, is that a file you had access to, you may no longer have access to, and it may not be in your possession, custody, and control. So, then, how do you go about requesting it? As a requesting party, you may have to do a non-party or third-party subpoena to get it from the party that has that possession. And I don't know if that's necessarily what would happen here, since it sounds like Judge Chesney has directed the plaintiffs to contact the podcaster. She's made it the plaintiff's responsibility. But to me, this is one of the things that I think makes is one of the key challenges of hyperlinked files is, these files can be anywhere and they may not be in your possession, custody, or control.
Right, right. Yeah, and all of that to me is entirely appropriate, but again, every time I read a case like this, Doug, it itches that nerdy part of my brain because I want to know, okay, what service were they using, right? From the behind the scenes when you and I record this, we're just merely recording over Zoom, and so I record the Zoom call to the cloud. So in order to get access to that file, I have to log onto my Zoom account and I have to download this video file of us, right? So is this the service that they were using? Were they using Zoom? Were they, there are dozens and dozens and dozens of services out there that will record podcasts, or did they just merely, post it in a Dropbox account or OneDrive or share file somewhere? Because they mentioned in here that the case goes through that the plaintiff and their attorney streamed the video, and I thought somewhere maybe it said that they could download it or they could not download it. Apparently, they did not download it. Right?
They claimed they could not download it.
Okay. They
And
claimed they could not
obviously
download it. Yeah.
that's what they claimed. And obviously it depends on how that was shared. That's certainly possible that all they could do was stream it.
Right.
But it depends on how it was shared. Yeah.
Because there are some services that you can say, I want, the recipient of this link to only be able to view it, but not to be able to access it, edit it, download it, print it, whatever the case may be.
Absolutely.
And so it's possible the podcaster may have shared it that way so that they could just stream it. And then they just merely said, can you cut out this section? I feel like if the plaintiff and the attorney were able to download a copy of the original podcast recording, whether it was a video or an audio, then I feel like at that point, maybe there would be a stronger argument to say that they had, quote, control over the file, even though that may be a copy of the file then at that point in time. But just merely being able to stream it, I don't know if that would get to the definition of control. But we know Judge Peck, obviously, and several others have been talking about this idea of possession, custody, control, not just in the context of hyperlink files, but of anything. There's different approaches here, and different courts, come at it from a different, like there's a practical ability test, right, and a legal rights test on this. So we know just even that question, besides the fact that the hyperlink files is still something that people are debating out there. But then you apply it to hyperlink files, and it just comes up with several of these points that you've already made, Doug. And just, it's almost like some of those traditional questions of, quote, possession, custody, and control, which were, again, developed around the idea of paper documents that you can see in your desk drawer. And how do you apply that now to modern ways that we utilize and access information? These are questions that, of course, keep us going and keep us interested in all of this. But it can truly be vexing, I think, not just for parties involved in litigation, but the judges as well.
Yeah, it's a unique challenge. And, and I could relate to this particular situation because I just did this with another podcast I'm involved in where we interviewed for, terrific eDiscovery women. And we already knew I needed to make an edit going in, and I made that edit. And then I shared it to them through Dropbox so that they could review it and approve it.
Right.
And that's the type of thing a podcaster would typically do. So in that case, being shared through Dropbox, they would have had the ability to download it. But we don't know again what platform they were using here to share the podcast, and whether there was a restriction placed there.
And that makes me mad. Because it's like, I want to know the details, but I'm not privy to them, and that's fine. But that's that last quick point that you're mentioning there. I mean, if the plaintiff and the attorney streamed this podcast from somewhere, then that means it's going to be hosted somewhere, and it's probably going to be in a cloud service somewhere. Now, I noticed that the judge stopped short, I think, of saying, you've got to go to the cloud. I mean, obviously, I think the judge did the right thing. I'm just saying, hey, the burden now is on the defendant, to go, or the plaintiff actually, to go back and try to find that. And I get that, but it's almost like I wish we could have had a little bit more maybe specific direction on some of that, but we don't always get that, and I understand.
No, we don't. And I mean, when because I had, like I said, in my case, pre-applied an edit to the podcast because we had one of our interviewees lost connection for a bit, and so had to restart and have her answer the question again and what have you. So cut out a segment. I was kind of the mindset of always save the original until. So I had a backup and edited the backup just in case. but not everybody might do that. So these are the types of things that it would be good to have more information. But I do think that, this is, to me, this case really illustrates how possession, custody, control of hyperlinked files may not be
Yeah.
in the parties, possession, custody, control, and if so, then what do you do? In this
Yeah.
case, Judge Chesney held on to that little bit of control, arguable control, and said, "Hey, plaintiffs,
Right.
go contact the podcaster to see if we can get the original, and if not, then I guess maybe sanctions are considered."
Interesting. Well, it's definitely a case to follow, and we can do that so very well through Minerva 26, the service from Kelly Twigger and her team. If you're a subscriber, you can actually, I think, follow this, and she does a great job of showing some related cases and everything too. And as we mentioned, this is such a big topic now. You and I have talked about this on Key Discovery Point several times, Doug. We did this, I think, back in December. Should hyperlink files be treated as modern attachments? I've written a blog post about this at nextpoint.com. I feel like I wanted to say the title of this, like, what's the deal with modern attachments? But they changed it up on there. That's good. And then you quickly just referenced a webinar that you and myself and Kelly Twigger did back in August for EDRM, which was amazing. We had an amazing attendance on that, so much so that we're actually going to bring it back almost about a year later now, that we are planning now to do a follow-up, like in covering all the changes and everything that has happened over this last year on this topic of hyperlink files. So stay tuned. That should be coming up from Nextpoint, hosted by Nextpoint, as well as EDRM. So more information will be coming on that, Doug.
Yeah, absolutely. And it's a rapidly changing area. There's been new case law. I think there's been new
Yeah.
technology developments. So I think it'll be a fresh look at the issue and where we are with it today.
Your key discovery point today: think about who has control over that hyperlink. Doug, as always, thanks for joining us. We'll see you next time.
Thanks, Brett. Thanks, everybody.